I am here, and I'm going to throw out an initial caveat. I was studying for my presentation this morning, studying so hard that I did forget my notes on my desk. So we're going to have to kind of wing it together, and I'll do the best I can. If there are questions or anything comes up, please just raise your hand, get my attention. I don't hold myself out as an expert on case law. I'm just somebody that practices in juvenile court every day. I've been doing so for about 11 years, like I said, with the Public Defender's Office, and now I'm in private practice for myself. In terms of my background, I've served in all capacities in juvenile court proceedings, but for being a prosecutor. So I've been a defense attorney for parents mostly, a GAL. I've been a GAL for parents. I've represented intervening grandparents and other parents and things like that. So what I thought we could do today would be kind of talk about the changes that have happened in the last year. And I'm just going up to about June because that was my assignment. So June of 2012 to 2013. I've got some groundbreaking news for you here. Wait for it. There wasn't a lot of big changes in the law in terms of in the last year. There have been some basically nuances and some language that has changed, and that has further explained things. But in terms of my reading of the law, there's nothing dramatic that I'm going to shock you with today. Okay? So I thought what we could do is sort of look at this from a perspective of, in terms of a person practicing every day in juvenile court, what the impact these cases have on us. So sort of some practical tips, some things that upon my reading of the case law, how I will change my practice, how my focus may shift, that sort of thing. So if there are questions, please raise a hand. Like I said, I'm not much of a speech giver, but I am certainly comfortable with talking and having a dialogue. In terms of, I've got about 10 cases I want to go over. I know that's pretty aggressive. I'm just going to point out some facts on each one and sort of the significance of it for today. The first one I wanted to start with was Chloe C. Chloe C. was an interesting case in that it was sort of, the mom in the case was sort of a latecomer. She got started on services very slow. She was still involved with a boyfriend, involved in a domestic violence relationship. She really didn't, right out the gate, as we wish these parents do, she really didn't get going on services. She was still kind of trapped in that domestic violence mindset. At that point, she basically started making significant progress once she got rid of the boyfriend. She took some steps that the court specifically noted on her own initiative. She checked herself into a domestic violence shelter. She sought out community supports. She did have caseworkers and people helping her along the way. Their testimony was actually pretty much in her favor at the termination hearing. So in terms of, she did, I think in this case, this was the one that she conceded, yes, the children have been out of home 15 out of 22 months. And so really the crux of her argument and the crux of her plea to the Court of Appeals was that she made continuous improvement. The children were not reunified at the point of the termination, but through the testimony that she gave, as well as the caseworkers, she showed steady progress. And the court, in many of the cases in the last year, brought up the continuing good point for us all to remember is that that perfection of parents is not required. Just good effort and continued parenting skills are what evidence of that. So in the end, the court said that there are grounds statutorily, but termination wasn't in the children's best interest in the end. Questions? Okay. So in that case, there was a reversal of the termination. She did get some more time. I always wonder when these cases are reversed, if they're not from my jurisdiction and I don't know about them, like, what happened then? What's the rest of the story? But unless you know somebody involved in the case, you don't really know. So the next case is Riley S. This one was interesting. It's a no-fault petition based on the, basically there was a child with mental health problems, and a lot of it was problems with truancy going to school. In this case, they came to court and the caseworkers requested of the court for some evaluations on the mother, and the mother objected. They also requested basically the mom had been in therapy prior to juvenile court involvement. They requested a release, so her therapist would have to talk to the caseworkers and have to write reports. In this case, the court said there's nothing pled that is about what the mother is lacking. It's about what the child's needs are. And so talking to the mom's therapist is not going to help the kid get to school, is sort of the way that I understood it. In terms of the court also, as you can see on that third bullet point, it distinguished it from basically fault-based petitions. And in all these cases, I think the distinction is good because it's just plain. It's just easy to understand. But basically, the gist of it is there has to be a nexus between the request and what is needed to correct the problem. There's got to be a connection. In this case, it looked like they were going after the mother on some sort of fishing expedition to find out more about her when it wouldn't correct the problems that brought the child before the court. So they distinguish it. This is a no-fault petition, so that's the important part about that. Any questions? Told you this stuff would burn you up. So exciting. I told you. Just hold all your questions. No, I'm just kidding. Ask it anytime. This case, it's not significant. It's not a surprise. You can look at some of my acronyms. Mom's mildly mentally retarded. The child has special needs in terms of medical needs and things like that. Basically, there was no progress made in the case, so termination was upheld. Why am I talking about that? Well, I'm talking about that because in this kind of case, this is one of the ones that I looked at and I said, gosh, this might change my focus depending upon my role. A lot of times, if you have a parent that is mildly mentally retarded, okay, they will have a GAL appointed for them, okay, to make sure they understand the process to the extent possible, okay? So if I'm a defense attorney or I'm a parent's GAL in this kind of case, and I see these facts kind of this is how the case comes in based on medical needs, based on special needs. What I'm going to try to do in this kind of case is not fight it, but I'm going to try to build relationships in this kind of case. If the child is in foster care, if the child is in relative care, how can we make this as much of a win as we can for everybody, for the child, for for my client, whether I'm defense or whether I'm GAL for parent. In this kind of case, it would change my focus. It would shift my focus in that. And I think that that's something, a lot of times, as you all know, these things are contentious. The parents feel like the foster parents are sabotaging. Somebody else wants their kid, stuff like that. If you can at all, either through family team meetings or through a mediation, something like that, sort of get to where the emotions calm down and we can kind of make it a win-win for everybody. This is one of the cases that is not significant, it's not surprising, but in terms of if I see my case line out with facts like this, I am going to try to work on those relationships. I am going to try to go about it a little bit differently, because if this parent can never parent, and if I just fight it the whole time, I lose. The parent loses, the case loses, probably the child loses because it lasts a lot longer than it needs to. So that's just sort of one of the things that jumped out at me about this case in terms of changing the way that I do things. All right. This case I thought was interesting in that they sort of split the baby on this one. They said that although they have, there's a couple different nuances to this one. Right before the trial, and I don't know if this was new lawyers or a mistake, or you just have to guess sometimes if it's not laid out in the opinion, but the trial judge said, "Are you alleging 15 out of 22 months?" And the prosecutor said, "Oh, I didn't do that. Whoops, I meant to do that." So they amended it right before trial, okay? So the father in this case said that was not anticipated. Basically, he had to allege that there was prejudice, and he didn't at that time. So basically, it's making your argument there. If he had shown prejudice out of the 15 out of 22 months, that new amendment, that surprise, then that would have, there could have been a different outcome. In this case, they didn't allege prejudice. The court said that 15 out of 22 months should have been anticipated by the father's attorney. Should have known. If you've been on the case, you should have known. And it's ultimately relevant to this termination hearing. So that's how they decided that first half of it. On the second half of it, I thought this was interesting because the father basically, at least in the opinion, we don't know all the facts of it, but in the opinion it said the father had an alcohol relapse. And shortly thereafter, they filed a termination, but it wasn't heard. And it wasn't heard for 16 months. And they stopped offering services to the father in this case. And what happened with this one is that they didn't have any testimony for the last 16 months because they stopped offering services. So they couldn't say how it impacted his parenting. They couldn't say how, basically, if there was more than one relapse. He had provided evidence that he was, had sober supports, that he was attending AA, and he kept visiting his kids. So this one, I'm guessing from the timing of it, was very much dragged out. But in the end, they said that there was insufficient evidence. By not offering services, there was no testimony to say how, it called it one setback. How one setback, one alcohol relapse, affected his parenting, affected his ability to remain sober and things like that. There was even evidence in the case, the opinion said, there was evidence that he hadn't completed treatment. He did show that he was sober, but he hadn't completed treatment. So I thought that one was interesting only in that we're like 50% win, 50% lose. They really split the baby on it. Any questions so far? All right. Oops. Okay. This is a case that I don't know, I can't remember where it took place, to be honest. I'm sorry if it's your jurisdiction, but this is the case that apparently there was 10 years of CPS, Health and Human Services involvement over about 2 cases. Sometimes the children were in the home, usually they were out of the home. Basically, the parents had a very, the parents had a very volatile relationship, on and off again. Mom moved to Texas, the opinion says, Dad followed her. So this appeal was by the father. In an interesting twist of things, I'll tell you the end of the story and we'll jump back. In this case, the opinion said that there were, I think, 5 children involved. They offered to both parents to go forward with the termination on the older 3 children and then file a fault-based petition so that they would get an opportunity to reunify with the 2 youngest children. Mom took the deal, Dad didn't. Dad took the stand in this case and denied the 10 years worth of abuse, and in the end kind of threw Mom under the bus and said, I wasn't beating her, she was beating me. So in this case, the children were placed in this is the case, they were placed in basically in the home of a maternal aunt. And so, and my thought was, is looking at it as a parent's attorney, Mom would still get to see the children at some point, given that it was kind of a relative that had placement and things like that. This domestic violence went on for so long and was so egregious. It happened in front of the children. It happened, somebody's in jail. Mom actually showed up to the termination hearing with a black eye. This is all in the opinion. So that one was just shocking in terms of, for me as a practitioner, I can't believe it went on for so long. You can't know, much about these cases from the opinion in terms of what were the nuances. They really just look at, the end result. Basically, this was the first case that I'm aware of that chronic domestic violence was identified as an aggravated circumstance under that section. And that's the first time that's actually been qualified as an aggravated circumstance. This case had a lot of history in terms of that 10 years of what had gone on and why they found it chronic. But this one was sort of like some new identification. I know that people, we've all sort of considered chronic domestic violence an aggravated circumstance, but this case really lays down the law and says this is going to qualify from here on out. Okay. Another thing in this case is that they actually had the children actually testified against the parents. The older children testified against the parents. So I don't know how you win from there or why you keep fighting from there, but that was sort of, I think, had to be very compelling testimony that these children didn't want to go home. These older kids that had seen it for so long didn't want to go home. This is one of the couple of the ICWA cases that came down. I think ICWA is terribly complicated, and I certainly don't hold myself out as an expert. But basically, in this case, there was a motion before the court to get the kids moved home. The interesting thing about it was that there was actual testimony, at least from the opinion, that returning the children to the parental home, either parental home, would not cause serious emotional or physical damage to the children. So there was actually evidence to the contrary. However, the court didn't buy it. And so that was interesting in that way. But specifically, it said that there has to be specific findings of fact in the order that's issued denying it. So that was interesting. They had, I don't know if some of you are familiar, I only know her from professionally courtside. They had Sherry Eveleth testify at that hearing. It was it seemed like a no-brainer in terms of the testimony that was elicited, but the court did not agree. So what happened? Well, I'll tell you, it basically sent it back, and it said that there wasn't evidence of, basically there weren't findings of fact, and the court went on to say that there wasn't evidence of the serious emotional abuse, psychological damage for the return of the children. So in the end, I don't know what happened in terms of, because the evidence was mom's appropriate, dad's appropriate. So I can't tell you the end of the story. It wasn't my case. Yes? Yes.
And they found that she wasn't a qualified expert?
They did find that they didn't go into it. They didn't actually say she wasn't a qualified. They didn't buy her opinion, is what I can tell you.
She said that it would be damaging to the physical and emotional of the children to return them.
She did not say that. She said it. She specifically said it would not be.
Oh, it would not be.
It would not be.
Oh, so she testified for the parents?
For the parents.
Oh, okay.
Yeah, they presented the ICWA expert. You know, I don't know in terms of the opinion. It's not my case, so I don't really know in terms of that. And in terms of the specific order, I think they would have addressed that in the opinion if they had made a finding. So I would think that they did not.
Because that happened before where they actually had an expert, but the county attorney didn't make, or the family didn't put the evidence there to make her an expert,
Sure, lay the foundation kind of thing. Yeah. Well, I mean, they made the law for a reason in terms of protecting Indian families and things like that, and I think that the Court of Appeals and the Supreme Court are very. I think that they've been citing the ICWA case and the Nebraska version, the NICWA case, a lot in opinions in terms of there are cases where I think it's this case. Where it identified that the mother, I can't remember if it's the mother or the father, that they had moved around a lot, and it actually talked about that Native American, that transiency, which doesn't sound like safe, stable housing, but it's common in Native American cultures. It's something that basically that the law recognizes. So it really is doing I really feel like they're honoring that and recognizing the cultural implications of Native Americans versus the rest of us. So I thought I had some hecklers here from my job at the Public Defender's Office. I was told that I was going to be heckled, and so I'm waiting for my heckling. I had worked that into my presentation, even though I forgot my notes.
So that's a request.
I don't know. I'm not begging for it. I do like the questions, though. Yes. You're going to heckle me later. I'm going to get out of here then. Oh, I'm just kidding. All right. All right. This is a case where you never want to say, that's some interesting, actually, you say things like, that's not bad lawyering, that's some interesting lawyering, okay? In this case. So this is a case that had a special prosecutor. I think it's out of Douglas County. I want to say from Judge Vernon Daniels. This is a case that basically the court changed the permanency objective for the children to not reunification, but one of adoption or guardianship. This case is interesting factually. It's horrible. This is mom's appeal. And this is the case where mom was in denial until the 11th plus hour that sexual abuse had occurred between her boyfriend, who happened to be the father of one of the children, and her oldest daughter, the Diana M. So they put efforts in place, they put therapy in place, and the opinion basically states that the children languished for 2 years waiting for the mom to get some insight. Okay. In the end, her lawyer said, now she gets it. 2 years later, the lawyer says, now she gets it. The interesting thing, and I just think, I question whether she gets it. So Diana was the oldest child, okay, and there were several younger siblings. Diana was the one that was sexually abused. So she didn't object to the permanency objective changing on Diana. You think she got it? She was older, but they didn't object to the permanency change on that. She only did on the other children. So the court found that basically, the question was, is this a final appealable order in terms of changing the permanency objective? And the court said, yes, absolutely, it is a final appealable order. And then looked at what the, it actually looked to the evidence and said, the court was right. We waited for 2 years, this family waited in 2 years, languished in foster care for mom to get insight. She hasn't, it's 2 years later. We have to do something for these children to provide them permanency. So that's sort of the way that one came about. Like I said, the court addressed both whether it was a final appealable order as well as was it appropriate to change the permanency objective. And on both, the court said yes, it's final appealable, and the court did the right thing, changing the permanency objective. Yes?
That was mine.
That was yours? Did I get it all wrong? Okay. I'm okay with that. Tell me why.
Oh, no, just, this was just a weird case.
You were GAL, weren't you?
I was GAL, and we ended up with the special prosecutor because mom's attorney argued conflict of interest with the public defender's office because there was an eliminated board meeting, and of course.
The county attorney's office or the public defender's office?
I'm sorry,
Conflict.
the attorney's office.
Okay.
Okay, and so that happened in like March of 12, and by the time we got that resolved, and the kids actually were home. At one point in time, mom had sued the therapist and to say she has insight she could protect, and it turned out to be false. So it sounds like this case went on forever, but what happened was we had a break with the special prosecutor, and then in the summer, July of 11, I guess, but that July, I got all the kids pulled again on that party board. And so the kids went home, they came back, and it took us from July until December to get that hearing on the ex parte order done, essentially in November. And so we never came back in for a permanency plan hearing for almost a year on that. So
Why did it take so long to get the hearing?
because we had no hearing until the hearing on my ex parte order was done. And we couldn't start the hearing on my ex parte order until we got a report of the special prosecutor. So procedurally, there were a couple of odd things that happened. So when we came back in January, it was actually the first permanency plan hearing we've had in almost a year.
Yeah.
And so that's why you go, there's a huge disconnect that it takes 2 years. Well, that's what happened from the timeline. And the judge said no further reasonable effort as well as changing permanency. And that's important because since that case came out a year ago, and what came out last January,
Mhm.
there have been 2 additional cases on jurisdiction, and then I have another one to argue next month, all dealing with changes in permanency as well as whether they're reasonable efforts or not, and if there's any kind of rehabilitation plan ordered. So that's really, that'll be the 4th case in, 10 months, dealing with the specific issue of jurisdiction is a final order, and what impact does what the case, if the judge has ordered, if the parents still do have on whether it's a final order. So we're tweaking, each one of those cases is tweaked a little bit. One, like I said, I have another, I have my second one this year on jurisdiction alone in October, and we got a homework assignment from the Board of Appeals on it, which is how I know we're gonna argue jurisdiction, because we got homework that said we will read this as well.
What happened in the end of,
That was
yep,
TPR's filed.
okay.
We're just waiting to get
See?
jurisdiction on the parent.
If you get the right people here, you'll know what happened in the end.
Yeah, no, we got TPR filed, but it's actually set, it's filed and it's set for trial in January.
In January? All right. Douglas County doesn't need any more judges.
Oh, yeah, that 6th judge bill's still alive for January, everybody.
Why do we need it? Just kidding.
Okay, so the jurisdictional piece continues to be tweaked and continues to evolve.
Maybe I don't understand what you mean by the jurisdictional piece.
The issue is what is and what is not a final order.
Oh, okay.
On Santana M, the court ordered nothing for the benefit of the parents,
Right.
nothing for visitation. The next case that came down, his name I cannot recall,
Welcome to my world.
well, it had a whole list of things. Even though it went to no reasonable efforts, they still had all these orders for things that was likely to still be planned. So that was not a final order. Okay, and so they've been tweaked, okay?
Yeah.
So the one that I'm
Are the kids 19 yet? I'm just kidding. Yes, sir.
Yeah, on this line,
Yes.
one item of shattering interest to me
Okay.
all the time
Okay.
is, when do I have to appeal? And so is what I'm hearing is we have a chain of cases trying to tell us what final appealable orders are?
Yes.
And we don't know what the answer is yet?
Well, we do, but we don't. I mean, on some.
Oh, thanks.
It's very clear that if nothing is ordered, like in Vienna M,
Yes.
there was no order for anything related to the parents. There was no reasonable effort of changing the permanency plan.
There was no way to rehabilitate.
There's no way to rehabilitate. They're on their own. On the case with somebody else put a name on, I can't remember that case. I can't remember the name of it. Prior to that hearing, there was a permanency plan that they had to do X, Y, and Z. After the court changed the permanency and went to no reasonable effort, they still had to do X, Y, and Z. And so they said, that's not a final order because they have all this stuff to rehabilitate. Okay?
They still have court orders that they're expected to
That's right.
fulfill, but we're not going to help you.
And mine kind of splits the baby because there was something ordered that they do, the judge makes a supervised decision. And so it's kind of,
Yeah.
not the dancing angels on the head of the piano, my case with dancing, body parts of the angel.
Ms. McNeil, was
Yes.
Diana M. a reported case or a memorandum of opinion? Okay.
What they said.
I see it here and I don't see the site, that's why I asked.
Well, I probably shouldn't tell you this, but I'm pretty technologically savvy.
Okay.
And this would be my first PowerPoint, so I was just kind of glad to get it out the door.
I have.
So, just another thing for doing confessions. All of these cases, and all of the cases, you can find a very good summary, I think a very fair summary. I read the summaries, I read the cases, on Through the Eyes of the Child's website. In terms of, you got something, you have a fact pattern, you have something that you want to look up, that's a pretty nice little cheat sheet for us. If I'm not good at remembering case names either, so that's a good little cheat sheet for you to sort of get you, get those keywords in, get that phrasing in, that sort of thing. Okay? I didn't know we were going to have a special guest speaker at in my presentation. Lynette Boyle, if you want to chime in anymore. Okay, she's busy. Let's see, what do we have here? All right. Okay, this was a case, Sudanese family, and it goes back and forth in terms of the, they spoke the mother spoke the Noor language, the children spoke English. It goes back and forth. At the first appearance hearing, there was an interpreter on the phone, but there was no lawyer. At the second at the adjudication, and Mom actually said at the first appearance, I don't understand. I don't understand. So that never, and they said, do you want a lawyer to help you understand? Yes. But that doesn't cure the I don't understand my rights and the consequences. And actually, I think in this case is the one where they actually never advised her of the consequences. They tried to get through the rights advisement, but they didn't. Basically, this is one that I am curious about what happens, and maybe somebody in this room knows, but what happens? So the case went to termination. The termination was reversed because of the lack of due process of knowing her rights and knowing the consequences and understanding those. So this is a case, like I said, that I'm curious to find out. In the end, it gets sent back, and what? Anybody on this case? I just thought maybe somebody. Anyway, so this is one that, this one had, I like this one in that it recognized basically cultural things, the language factor. If you're in Western Nebraska or something like that, they use the language line. You know what I mean? I think that's the best they can do sometimes, better than nothing, but I would hate to be a parent in those shoes and having someone on the phone tell me sort of what a judge is saying really seems like something that one should absolutely understand and comprehend the consequences when it's, the most serious subject matter that there is of taking your children away and possibly terminating your parental rights. That's something you should understand. There should be no question about that. The court found that there was no due process there. So let's see. Okay. This one, like I said, I've already qualified myself as not an Indian child welfare expert, so we're clear on that. I would not be able to testify. But this is basically it's a jurisdictional question, whether to transfer a case to the tribe or not. And in this case, basically, there has to be good cause shown, and there's a question about that, about what stage of the proceeding you're at. Okay, if it's the beginning of the case, or in this particular case, the tribe intervened right at the beginning of the TPR or when the TPR was about to begin. Okay, and what the court said is that it's a jurisdictional question. Don't talk about best interests. This case also did a lot of, I felt like it really did an honorable job of talking about the Indian Child Welfare Act, the provisions of it, about Native American distrust of the, I don't know if it said white Anglo-Saxon legal system, but that it kind of went into some of that stuff, which I felt like you can read the law and you can read statute or whatever. This sort of, I guess it sort of explains some of the underlying reasons, which I don't know the history of ICWA, the underlying reasons of why they established it, basically that there is some distrust amongst non-tribal courts about transferring a case. It went into that, but it basically said you have to show good cause, okay? And in this case it said the timing of the filings, it doesn't start from the beginning of the case. It said that basically the date of the filing of the TPR, not from the beginning of the case. The court has to consider that as good cause, and it said that it wasn't, okay, the timing of that. It also said that basically best interest is not something that you should not be considered in a jurisdictional issue. Basically said those are two separate things. Jurisdiction and best interest are two. Don't apply best interest to whether a case should be transferred or not. That's not the analysis one should do or a court should do. Okay? Absolutely. And they're sitting next to each other? How nice is that? I don't see any Douglas County attorneys here. Just kidding. I don't. Yes.
And we have briefed, the petition for cert is actually set for Monday. So this Supreme Court to decide whether or not they're going to take it. Of course, it's a snowball's chance in hell to have your case taken.
Yes.
But there has been some good press out there on it. So if you want an answer on whether this is the nationwide law or not, you should vote yes for the Supreme Court to take that case on Monday.
They don't allow voting, right? No, I'm just kidding. Is that like a thumbs up or something, or like it or something? I don't. Okay. Well, I like doing these things when there are people that are involved in these cases. I think it makes it more interesting. And like I said, I go off the opinions, and sometimes there's so much more to the story. And I usually think when I have all my brilliant appeals, they sometimes just don't get it. I don't know how they miss it. But I had 3 cases in this time frame that came up for that were on appeal. One of them was my direct appeal, and 2 of them were cases that I represented somebody else on. I represented a dad and the mom appeal, that sort of thing. So I don't know why they didn't buy my argument. I won't go into my case. Just kidding. All right. So. This is probably one of the cases that Lynette Boyle was talking about in terms of, yes? Right, no. All right. I was trying to come up with something clever about that, but the year of jurisdiction, you can't really top that, can you? Age of Aquarius or something, year of jurisdiction, I don't know. Yeah. Okay, so this is the case that, basically a case out of Lincoln, Judge Heidemann, I think that basically there was a temporary suspension of visitation and on this case, and the court basically wanted to get some input from a therapist is what it sounded like, wanted therapeutic visits to occur. It was meant to be temporary, a temporary suspension of the visitation for the family. The language specifically, it goes over again, no new law here. It just sort of analyzes the facts in regards to this, and it said that basically whether it's final appealable doesn't affect substantial rights. They're saying that a temporary suspension of your visitation because there is a plan to resume visitation does not affect a substantial right, so therefore is not appealable. I always wonder in cases like this, so it took you about a year to figure that out. You could have just waited 30 days. I don't know, 60 days. But you just don't know the background on it in terms of that. But it takes a long time to get through the appellate process, and sometimes you have to make a judgment call on, as a lawyer, of appeal it or not appeal it. Would it take longer, and could I get more done by not appealing it faster, that sort of thing. Sometimes you're right, sometimes you're wrong. That's all I have.